everyone. My name is Dan Chu, and I work on the SJC Exchange site, as well as the network meetings for Safety and Justice Challenge Network. June is our quote unquote membership month at SJC Exchange. So I just wanted to take a minute or two of the time out of this session to very quickly invite any of you who are possibly new to the network to make sure that you join sjcexchange.org. It is the official online home of the Safety and Justice Challenge Network, and has a lot of very useful and helpful. Thanks, Ashley. There's a discussion board that's used widely on a daily basis. You can post your own questions. The reports are shared, new articles, anything related to the efforts of the SJC Challenge. There's also a very useful upcoming events tab, where you can see webinars that are coming up and other events that you might be interested in attending. There's a resource library, all sorts of very useful information. So if you are not yet a member, I urge you to join today. On the upper right-hand corner of sjcexchange.org, under the About tab, there's a Refer a Colleague, and you can kind of join from there. We used to go through an approval process. That's no longer the case. So if you're not yet a member, you can become one right away. So I wanted to, again, urge everybody to do so. And if you have any questions, feel free to reach out to myself or my colleague, Tamara, who's also on the call. I'll put my email in the chat box, but it's just dan@pretrial.org. And Tamara's is tamara@pretrial.org. If you have any questions, feel free to reach out. And thank you, Ashley, again, for giving us the time.
Yeah, absolutely. I just want to echo that this is a really great resource for especially our newer sites that haven't been involved with the SJC for as long, but there are really years and probably thousands, at least hundreds of posts of resources and products and things like that I think collectively this serves as a really nice resource for best and promising practices throughout the SJC, and feel free to take advantage of that. You don't have to heavily be involved in other SJC work to access it, but as Dan said, it's open to everyone. We also have an Impact Network specific kind of smaller community page for just these 11 sites that feel free to join that, or let me know if you can't find it and we can get you looped in, and that's where we post the resources for these calls and kind of associated things that are just within the Impact Network. So a lot of resources that I think are helpful there. So thanks for that, Dan.
Thank you.
All right, so we are going to get into the meat of today's presentations. And first of all, we're going to turn it over to Milwaukee. We have a few folks from Milwaukee talking about the pretrial diversion efforts they've made there in their several years of being involved with SJC up to this point. So Mandy, I think I'm going to hand it over to you first, or to Tom.
Sure, and I've actually noticed that Tom Reed is not quite on the call yet, so hopefully he'll be jumping on soon. I have not gotten a response from him. It seems as though it's been a morning of unexpected hiccups for us here in Milwaukee, but I am here and I will launch us off. So my name's Mandy Potapenko. I serve as the director of Milwaukee County's Community Justice Council, which is our criminal justice coordinating body, which has been our lead applicant and kind of body driving our MacArthur Safety and Justice Challenge work. And just to kind of set the stage for Milwaukee, for those who have not kind of followed our path here today, Milwaukee is a city of about 500,000, a county of right around 950,000. We're located right on the shores of Lake Michigan, and it's beautiful. We're having a plus degree day today. So it's very different than our winter months. But we as a jurisdiction have, as a criminal justice system, have really focused in on this intersection of behavioral health and criminal justice, recognizing our local desire to have fewer people both in the jail as well as in custody when mental health is a driving factor in their behavior. So our Community Justice Council has had a mental health committee since our inception, which was in 2007. And in those discussions early on, we began doing paper-based heavy utilizer analyses where we had the police department kind of looking at their CAG calls and finding places where individuals with calls for service related to mental health concerns were being cited or being called, police were being called to the scene all the way back then. And we had our public defender's office and some of our pretrial staff would try and then get releases of information. So then we could, begin some of that information sharing at a very early paper-based time and really try and impact and affect individuals so that they were not deeper and deeper into our justice system. Fast forward a number of years in our early stages of our MacArthur Safety and Justice Challenge work, and we recognized that we wanted to further advance strategies and formalize strategies around the intersection of behavioral health and criminal justice. And so in the early stages of implementation, we had a post-booking stabilization program that wrapped housing resources and some additional navigation around individuals who were coming into our jail who had significant behavioral health needs and were oftentimes otherwise cycling through our system. That program during the first year or so of implementation, from a qualitative perspective, was successful from the standpoint of really being able to work with individuals and try and meet their individual needs. It was very effective. Where we saw some shortcomings with that program was just the number of people that we could actually serve, as well as then the costs associated with the services we were trying to provide. And so as we began to reevaluate the future of what was our post-booking stabilization, we really began conversations around changing our process rather than focusing on implementation of programs. In Milwaukee County, and Claire can speak to this, and others on the call will be able to speak to this, Milwaukee County has had in early interventions pre and post-charge diversion program for many years. So what we chose to do as we moved beyond our post-booking stabilization was really look at adding to or supplementing that early interventions program that's already in existence, and be able to really change the process in which we go about early identification of individuals who have mental health needs, as well as then finding ways that we can quickly divert or deflect them from the system with quick connections and embedded connections into our local county behavioral health system. So with that, I'm not sure if Tom Reed has joined on our call yet. I'm not paying attention to our attendees. But so I will instead just introduce both Claire Starling and Dana Blake, and hopefully Tom will be able to join us as well. And the reason it's important that we have all three of our partners here on the line is really it between our DA's office and our public defender's office, they have long worked together on this early interventions program. However, we've recognized that adding the connection directly to our behavioral health division has been a critical asset for us. And the county has now since permanently invested in having this position that is the liaison between our criminal justice and behavioral health systems. So with that, I will turn it over to Claire. If you'd like to introduce yourself in between, Claire, you and Dana can go ahead and just kind of talk a little bit more about the work that you do. So thank you.
Sure. Thanks, Mandy. Hi, I'm Claire Starling. I'm an assistant district attorney with Milwaukee County DA's office. I've been in the office for 18 years, and I've been in this position for almost 3 years now. I work directly with Dana Blake, who's also on this call, and the public defender's office. And we have come up with a really successful program for diversions and deferred prosecution agreements for mentally ill clients in Milwaukee. So I work directly with 3 public defenders who are also assigned to this position on that side. And we all work with Dana, and we get referrals from all around our office for mental health cases that would be potentially eligible for our programming. And before we decide anything, we send the name and the information over to Dana, who works for the behavioral health department. And she sees if she can get a release of information from that person, especially if they are in services or if they're in custody. And we go from there, linking them to services and programming and seeing how we can best help them help their mental health needs without putting them in the criminal justice system.
Should I tell them? All right. Hi, everyone. I'm Dana Blake. I also am in Milwaukee County. I work at BHD. So like Mandy talked about, I am the criminal justice liaison, which kind of transferred from the post-booking stabilization. And what I ultimately do, like Claire said, is try to connect BHD with the criminal justice side. So I get a jail list of everyone that's going in the jail. I spend time reviewing each client, seeing if there are people that are in services or would benefit from services, and I flag them if I can. And like Claire said, work on getting an ROI, talk about what services they might need for their mental health, and get information from their community providers. And then if I can get that release, I will provide that information to Claire, which will help her determine, you know, if we're going to go the early intervention route or a different route. And then I also get referrals from them to reach out and try to find information for the clients if they would benefit from services. If clients aren't in services, I can do an assessment for services. So I think that is the benefit of my position too, is that I can help determine the best level of care, whether that's outpatient or our highest level of care. So that is kind of my role. If there's more questions, I would be more than happy to provide more details. But it's really just trying to coordinate and get that release and that client buy-in to engage in services versus incarceration.
Reggie, you're muted.
It's so rare that I'm actually muted, you know. People wish that happened more often. Thank you guys very much. I'm wondering, Dana, if you can talk a little bit about the Excel spreadsheet, and you mentioned kind of the key thing, which is that, and Tom, thank you for joining us. So Mandy's given a great overview of how we got started. Claire's talked about the prosecutor's role. Dana's talked about the role for her work in identifying folks and whether resources come from. I'm going to turn it over to you in just a second here, Tom. But Dana, one of the things to maybe, you kind of queued this up, is that really looking at the level of care. So I think one of the things that you do is look at if the person's been known to the behavioral health division, at what level of care they might be at. And then if that is what you're also feeling is the correct level of care, if there needs to be some adjustments to that. So if you can talk a bit about that, and then kind of that broader, we'll go to Tom and then maybe back to you, Dana, to talk a little bit about some of that broader issues around some of the kinds of data and resource connections, some of the challenges also that you have. Dana?
Sure. So Milwaukee County Behavioral Health Division gets a lot of referrals for people who need mental health services. So we do luckily have a lot of different levels of care in Milwaukee County. We can go from outpatient all the way to group home funded services. We have TCM, which is targeted case management, CCS, which is a Title 19 funded program, and CSP, which is one of our higher levels of care, community support programs. I think a lot of communities have community support programs, but not a lot have that targeted case management. I think Milwaukee County is kind of unique in that one. So we have a spectrum of services, and then we determine the level of care based on diagnosis, based on contact with hospitals or crisis services, BHD, you know, things in the community like that. Or if this is their first time ever getting mental health treatment. So I do help determine the best level of care that way, because sometimes just connecting someone to a psychiatrist or a therapist is all they really need to improve. And then sometimes they need all the way to CSP, where they're getting 7 days a week med monitoring. So we're really using my access to our behavioral health medical record, and then some history that we can find to try to determine the best level of care to connect them to whatever that might be. Does that kind of answer your question?
Yes, thank you, Dana. I just think that's a really key part, is to make sure that people are getting access to the level of care they actually need to have. Tom, let's bring you into this conversation, and welcome and thank you for joining us from Milwaukee. Introductions.
Yeah, very happy to join you. I'm sorry I was a few minutes late. I think what I would say about and personally, I can't overstate the importance of this project. It seems to me, from both a local and a national perspective, the over-reliance on the criminal justice system to work with people who have chronic and persistent mental illness chronic and severe mental illness is a major problem, right? And we've had, as I'm sure has been explained, a long experiment running with what we call early interventions, which takes lawyers from the public defender's office, pairs them with lawyers like Claire Starling at the front end of the criminal justice system to try to find, where it's appropriate, avenues for early decision-making that is more remedial and hopefully preventative in its focus. I think in working with people who we see in this category, there are some challenges that it takes some special training and skill and aptitude to manage if you're a defense attorney. So when you meet a client who is potentially going to be subject to some kind of decision that's being made by the district attorney's office that would involve a diversion agreement, or might involve even a decision not to prosecute, but with the idea that the individual is going to get some guidance about, hey, you're not getting prosecuted today, but you really have to do A, B, and C in order to prevent, something happening in the future. We're seeing people who have serious mental illness. Many times they are symptomatic. We really can't do this very easily with people whose level of symptoms is so extreme that they really don't understand what's happening. But all too often, we find people who do understand enough about what's happening that we can work with them, even though we might be concerned if they were to be criminally charged, that they would not be able to manage the responsibilities of being a competent criminal defendant. They might not be able to decide whether to plead guilty or to have a jury trial. They might not be able to decide whether to testify or not, but they can understand that they've got themselves into a difficulty, and that there are some options that are being presented to them today that would be desirable. So the communication skill it takes to work with people who are in that predicament is not available to every criminal defense attorney. It takes an understanding of these illnesses. It takes a certain kind of skill at de-escalation. It takes a kind of direct way of communicating when people need to hear something that's not offensive. But it also requires a mastery to some degree of the array of community resources, because it may be that District Attorney Starling would say, I'm willing to consider doing something in this case, but I need some reassurance that, that there's housing. I need some reassurance that the medication regimen is really appropriate. And if it isn't, that it's being addressed. I need to be sure that there's a psychiatrist appointment that's visible to, in the very near future, so I can be certain that, and the people who are the victims or alleged victims, that they can be sure that this intervention is going to be effective. So in a very short amount of time, a lawyer really needs to be able to get on the phone and tap into resources that they're comfortable with to get some answers to questions like that. And I think that's very challenging. And there are barriers to getting those answers sometimes. And that's where, having our BHD liaison, who you've just heard from, is a big help, because sometimes that helps to reduce the barriers of communication. And sometimes it just takes, again, a mastery of how to go about talking to people who aren't in the criminal justice system about how it is that they need to give us some information so an important decision can be made that's going to be better for everybody.
Tom, thank you very much for that. I think that, and I saw Claire, you agreeing with a lot of what Tom was saying, is that understanding what's going on is so critical in order to be able to make those decisions. But the access and availability of services is really key. And that in part, some of this is really almost that strategy again around that diversion to services instead of the regular criminal justice process. I'm wondering, Claire, if you have anything to add to that. And Dana, can you cue us up with how many people that you've seen? Did you do that?
Sure. Do you want me to go first?
Yeah, let's do that.
Okay. So I keep a spreadsheet of everyone that either Claire has referred to me or that I have identified in the jail that have services or would benefit from services. And the spreadsheet started with the person that was in the position before me. But as of last week, we have identified or have contacted, or Claire has referred, at least 1,340 people that we have found that were in services, or we've assessed, or we've connected to services in some way or reached out. So we're at that number. Do you want more details on any of those, or just the general number?
No, I just think that's really helpful to look at that volume of folks. And I think one of the things that Claire spoke to and Mandy spoke to earlier is pivoting from a program that was doing some of the same effect, but was more limited, and now broadening it out with this particular model and being able to really get to a fairly large version in the last couple of years in doing this particular work. Claire, any other thoughts from you around the service delivery and the population served?
I think that number is really important too, Reggie, because so we can't just count the diversions that we do or the deferred prosecution agreements that we do or the cases that we charge, because so many of these cases, Dana and I kind of work together and divert them completely from the system. So they're not even under any sort of contract, and this person is going to be hospitalized at BHG. Well, what's the point? We don't charge the case then, so it's super important to work with your local behavioral health division, I think, because a lot of these cases don't even need to be in the system at all. So I think that number is really telling of that too.
Thank you, Claire. And I think part of that in what's common in Milwaukee is really this belief about getting people to the right level of services and interventions, and that the justice system may not be that appropriate place. And coming out of the prosecutor's office, that's really key. And then having the relationship between the prosecutor's office and the defense about making those decisions and really having some good agreements about who's really who you're really able to deflect and divert from your system. So thank you for that. Dana, any other data stuff that you have? I'm wondering if you know how many returns or repeat clients there might be.
So I have a general idea because we have an initial referral source and then a secondary. So that usually means they've come along at least once. And so for the secondary referral source, I have a total number of like 400 out of that 1,300. We do also, we do also track like what level of care they were in, what level of care they end up in, if they end up in a level of care, if I can't contact them, gender, race, things like that is what I kind of track.
Thank you. And again, that number is really important. And Tom, I don't know if you have any thoughts about that, of those folks who are still going to come back through again, because the diversion opportunity is there. And also the understanding that especially serious mental illness can be very episodic. And just because somebody has gotten a chance to get to services doesn't always mean that service engagement is going to stay at a level, or the person's not going to come back through on the system again.
Well, I guess what I would say are, first, these are relapsing or remitting illnesses. So people are going to have periods of pretty good stability. They may live in full recovery even, that's what we always hope for people. And then unfortunately, these illnesses can relapse. So I don't think the expectation can ever be that a person is going to live a life that's symptom-free. I think to get somebody who is having a multitude of problems which exacerbate the mental health conditions, so that they have interfamilial issues, they have housing or homelessness issues, or maybe they just have issues around finding meaningful things to do with their life. I think sometimes people's symptoms are exacerbated because they're not doing things in life that give them purpose and meaning. I think when we have a client, what we're trying to do is work with every resource we can to be a bridge between the moment of crisis to a place where there's a higher chance of their achieving that recovery and that stability, knowing full well that having achieved it, they may still have a subsequent relapse and return. I do think that we're somewhere along the line of being able to identify in a very proactive way who are our familiar faces and how can we go upstream with them. Our county did one project to deal with chronic homelessness, which had the benefit for the people who were subject to it to give people housing, and not dry housing, but just housing, and to co-locate some services. And for that group of people, their demands on our mental health system and our criminal justice system and our municipal court system went way down. That's just a small project, but it's an example where if you can really find the people who are in this category and really work with them, when they do have the relapses, there's a chance to not have the whole bottom fall out for them, that there are people there to help them to succeed. And so I think this is a work in progress.
Thank you very much, Tom. Claire, Mandy, Dana, any other things from your perspective about the jail diversion work that you guys have been involved with? Okay, so then I think that, and we'll have time for some other conversation later on, but Ashley, I think we'll turn it back over to you. And I think you'll be bringing Domingo in.
Sure, thanks, Reggie. And thanks to the entire Milwaukee team. I know there were a host of issues that you all have been juggling over the last couple of days, so we appreciate your sharing in time today. I would like to bring up next Pima County, Arizona, and Domingo Corona, who's the pretrial services director for Pima, and we'll hear a little bit about what they're doing as far as pretrial diversion. Domingo?
Yeah, hi, and it's good to hear from our cohorts in Milwaukee County. I know they're doing a lot of great work there, and I know several of the people that work there, and just, we also in Pima County respect a lot of the things that they're doing, and try to follow along in their footsteps as well. So it's good to hear all that. So what I'm going to talk about is our STEPS Smart Diversion Program. It's a pre-charge diversion program. It's not a drug court. It's a drug diversion program. I'm going to highlight that and then kind of to quickly talk about, you know, how that fits into our wider scope of work that's being done in Pima County around substance use and behavioral health. Next slide, please. So for those of you that don't know me, I'm the pretrial director in Pima County, Arizona. You know, I am involved in several groups nationwide. One of them is the NAPSA, National Association of Pretrial Service Agencies Board of Directors. I also work with the National Institute of Corrections Pretrial Executives Network, and I've been on several groups with SJC. One of them is the risk management group that looked at risk assessment and different avenues of risk assessment. So, you know, I've had some experience in this area, and I really, the reason I mention that is that, you know, I get to hear a lot of stories about what's going on in the pretrial phase, in the pretrial world, I'm sorry, across the country, and what unique programs are out there, how they're managing, and, you know, so really the work we're doing in Pima County, yes, I think I'm really proud of what we do, but I think it's also a collaborative effort to come up with programs in this area and really make them work. Next slide, please. Okay, so what is STEPS? Here's the goals of what I'm going to talk about is, you know, we're going to talk about, you know, what's the STEPS diversion program, the purpose and goals. Next slide, please. And so what is STEPS? You know, what is STEPS diversion? So really it's like I said, it's not a treatment court. It's a partnership between us and our prosecutor's office in Pima County. It looks at possession drug charges really. So in our STEPS diversion program, we're only bringing in cases that have a class 4, class 6 possession of narcotic or manufactured drugs. It's really an expedited release process, and it fits in the bigger picture of what we're doing in Pima County. So really quick, so STEPS is dealing with drug cases. We've also worked, and really through SJC, we worked on also behavioral health, you know, cases coming into the pretrial phase. So from initial appearance on, you know, we have separate programs for those two, you know, main areas of work. And I'll kind of get into that a little bit later and how the screening around that looks. We started the program in February of 2021, and now we're over a year in, and we have some good data around how things are going with it, and I'll share a little bit of that. Next slide, please. And really, I want to get to the point where we're having a conversation. If there's any questions or comments about this, I really want to answer those. So, like I said, it's pre-charge. You know, it's a pre-charge diversion program. Pretrial Services manages the screening and supervision of the program. And we also work with service providers. We manage what we call IGA, not IGAs, contracts, service contracts with the service providers locally here in Pima County. And we have active stakeholder engagement. In other words, we meet very frequently with our prosecutor's office, public defense, the court, and county government to work out issues. We're actually also well connected with our behavioral health department. And in working with STEPS. Next slide, please. So what is the mentality behind our STEPS diversion program? Obviously, treat drug cases differently. You know, and this one point here for this group, I wanted to kind of hone in on. So in Pima County, you know, we really don't incarcerate very many individuals who come in with drug cases. 91% of our drug population, if it's not for sale, get released at their initial appearance. So pretty much everybody's getting released. If they're not getting released, it's because they have other issues like another charge, or they have a probation hold, or a parole hold. They're really, most of the cases that go through initial appearances are getting diverted into special programming. What we did when we started looking at STEPS, we looked at a couple places. One is Deschutes County, Oregon. They have a pretty good system that was in place. We found that program through SJC, and we also found the program in Harris County, which I think they call the REC docket, which is how a courtroom is organized around the pre-charging diversion. So we took those two programs and meshed it into what we wanted to do here in Pima County. Like I mentioned, we have strong partnerships, and again, one of the things that I'm most proud of is the partnership with behavioral health and our county health department, because that's really where we get into discussing peer support. They provided us with some good resources around peer support in that area. Next slide, please. So I'm not even going to try to explain this. The process, this is what the process looks like in Pima County. The reason I have this slide here is I just want to talk about really quick, how many cases we get. So this slide will tell you we have about the potential for people that can be in our STEPS program is close to 3,000 individuals a year. That's not how many cases are getting screened in because of the standards placed around entry. But this is this slide, again, I'm not going to explain it too much because it is pretty complicated. I'd rather get to conversation. This slide just kind of tells you how we formatted the case processing around STEPS. Next slide. So what were our challenges when we set up the program? Because it's a pre-indictment and pre-charge in Pima County, we have the county prosecutor has 2 weeks to formally charge somebody. So we needed to accomplish setting up a diversion program or diversion/deflection program within that time frame. So the challenge was moving cases to Superior Court because in Pima County, we don't have a direct to felony court processing. We have a limited jurisdiction justice court that holds the cases for 2 weeks, and then they get into Superior Court after 2 weeks if they're indicted. So we needed to create a brand new court process, which is why the prior slide was pretty convoluted. So the first thing we did was we set up a case processing around the diversion program. For steps on the hearing date. So once they have a hearing date, which we call a PI date, it's a preliminary pre-indictment court date. At that hearing, they meet with a public defender. They go over a contract. It's a pretty standard, diversion agreement hearing. And then we pretrial will meet with them right after that to talk about what happens next in their diversion plan. If the terms of steps are not met, and most people who show up to their hearing are getting accepted, I think we had pretty close to 100% acceptance rate. That's not the challenge. The challenge is getting people to that court date. But if the person doesn't get to that court date, then their case is either moved on for further prosecution or it's dismissed. Next slide, please. So what is our role, pretrial services role in STEPS? And I really kind of want to talk about this a little bit more. So we do some screening. So we do all the screening for the STEPS program, and it's all pre-initial appearance. We facilitate the case processing conversations and make sure that's working smoothly. We do outreach for their initial appearance and outreach if they don't show up. We try to contact them if they don't show up. And we do the supervision for the diversion program. Now for the screening, I really wanted to talk about this because, like I said, this STEPS diversion is only half of what we're doing for the pre-charge, pre-indictment population. We also have what we call enhanced supervision, which is screening people quicker at initial appearances. In other words, before we started working in this area, we didn't really do any behavioral health or substance use screening. It was actually, PRI helped us find some good screening tools to screen the population. So we were able to identify some screening tools that were not clinical in nature, but able to determine readiness for referrals. In other words, our goal wasn't to, hey, this person needs this level of substance use or behavioral health treatment. That's not what we wanted to do. Pretrial officers are not suited to make that assessment, in my viewpoint. We wanted to make sure that, if we're doing anything for them, it's below conditions of release that are set at the initial appearance hearing, and it's supportive in nature to get them, off to a program. So we implemented behavioral health screening and substance use screening, and eventually we're going to implement trauma screening. So we use the ACO, and Stephanie Garbo asked in chat, we use the ACOK tool. We used to use the Brief General Behavioral Health Screening tool, but we wanted to keep our staff, properly trained. Eventually we're going to split it up again, but at the before initial appearance, we were using the ACOK. We got that tool referred to us from a couple places. One was Sean LaGrega, who works in Maine, which Stephanie, I think you know him. So they were using it in Maine to screen for the diversion program. It was a dual function tool that temporarily we're using to get people, situated or sent off to the proper referral source. So we do that at initial appearances. We screen for that. They go to initial appearance court. If they get placed into diversion program through STEPS, we use the TCU 5 for substance use. if they get placed into enhanced supervision, which is our behavioral health and non-diversion program, which is pretrial supervision and a supportive program for pretrial supervision, that we use further screening tools there. We use a TCU5 there as well. And I want to make sure I say the right tool we're using, but I think we're also re-scoring the ACOK and maybe also using the brief behavioral health tool. So, you know, that's kind of something that with SJC we really ramped up was, you know, increasing the amount of screenings that we use, making sure they're more specific. Before we worked with SJC and PRI, we just had some random questions that we asked people. You know, what behavioral health treatment have you had? You know, we even had this really a couple weird questions that I don't know where they came from, and we need to get rid of those and get something validated in place. So I think that's one of the bigger benefits for us is having some guidance and how do we screen the behavioral health substance use population to do something meaningful that doesn't involve court conditions of release being set, making people go to treatment. So, you know, those are some of the key components that we implemented, not only with enhanced supervision, but also with our STEPS diversion program. We didn't want anything to get into court conditions of release, and they usually almost always do not. I would say maybe 98% of the cases that get passed through initials don't have a treatment condition, don't force someone to connect. They really just focus on, you know, what do you need to do during the pretrial phase to go to court, et cetera, and protect community safety. So we're really careful about that. Next slide, please. So, and here's the answer to the question, Stephanie. I almost forgot that it was in my PowerPoint. So, you know, initial screening, it's preliminary program eligibility. Housing needs is something we have implemented due to a BGA grant. You know, so we have a housing needs tool. And what we do is if someone qualifies, you know, what we do is we refer them to a local provider who is funded. We have a funded peer support specialist working for a local housing provider who tries to get them into housing for STEPS diversion. And then again, the ACOK tool, that's the readiness for referrals tool that we use for its substance and behavioral health is a dual screen. And like I said, I think it has a trauma piece to it that we're just not using right now. So the triage screen happens at, you know, the STEPS court hearing once they're accepted. That's where, like I said, we use a TCU5 screening tool. It's not proposed. It's actually something we're using now, and it's conducted by a pretrial services officer, or we've actually created a diversion specialist classification within our court. So it was really a person who's more aware, you know, of what's going on in the service provider realm, someone who has experience with pretrial services as well. This person's a lot more able to, you know, direct someone and work with providers who they know. So we really ramped up in this area, being able to connect someone to services. And then there's an actual clinical assessment based on our TCU screening tool. So an ACOK tool. So what we do with STEPS is we have 2 levels of referral. If they're low needs, they're going to go to drug education classes, which are led by peer support specialists working with our behavioral health, with our Pima County Health Department. So there, you know, there's that range, you know, realm of work for those people that are low needs. If they're higher needs, then they get sent to a service provider for a clinical assessment, and that's what the assessment here you see is. It's a more drill down. It uses a Arizona approved clinical screening tool to move that person forward. Okay, next slide. So what happens at the first STEPS hearing? So at the first STEPS hearing, you know, they're making sure the person is willing to accept the terms of the STEPS program. There's some conversations about appearance and, like, you know, what do you need to do to have a support you getting to court or to the providers. You know, after that, you know, we schedule weekly case management meetings, pretty standard for a diversion program. So in other words, pretrial leads a conversation around, you know, each individual case. What is this person doing? Are they connecting? Have we heard from them? And then we schedule review hearings if they're struggling in the program, you know, so the person then at that point must attend and you know, maybe the judge works with them, the parties work with them, and then they graduate and there's program dismissals. I will say that, and I heard, I think Tom Reed talking about, defense attorneys who are more invested, or more knowledgeable in this area of work. That's, I think, one of the things we learned from the Houston RIC docket program, is that we don't have prosecutors defense who cover all cases work in steps. The specific prosecutors and defense attorneys who are bought into this kind of work. So we only have one or two of each working in the steps program, and they don't rotate out. And they are people who are a little more bought into helping this population, but also who also understand the what's out there in the community. In addition to that, our defense services has hired some social workers to work with this population. So that not only do they meet with us, but then they'll meet with the public defense services social workers who do some extra things if they need to get that person situated, or look at other resources that public defense will connect them to that are supportive to the overall diversion program. Okay, next one. So here are some numbers. So as of January is the last time we did a vetted data dive into steps. It was a little close to a year through the program. At that point in time, we had 281 individuals accepted. We had 12 people that were in diversion program, housed in service provider housing through our grant. And the good and the bad, nearly 100% of participants who appear accept participation and proceed, but about 50% of those who are eligible do not appear at their first hearing. So that is a challenge area, getting people to that first court appearance. I will say though, we have in Pima County, like I said, we release most people charged with drugs. So it doesn't matter what risk level they are, pretrial risk level they are, whether it's low to high risk, they're usually going to get released. And for the moderate to high risk population, our failure to appear rate at the first arraignment hearing is about 60%. So actually, if you compare standard pretrial supervision to diversion, we're getting 10% less failure rate for this already challenging population at the steps hearing, and it's starting to increase. I think it's getting up to 55 to 60% now, and that might just be word of mouth, getting people to know that there's a program out there. So when our program is fully engaged and we have releases coming to us at a normal rate, we had a decline in December and January due to that COVID bump. And we had the prosecutor not have these cases come in at all. They weren't charged. But once the cases are back up, and getting booked again, our caseload in this program is about 160. So that's at any given time. So we're happy that we're reaching out to a good number of individuals. Next slide, please. So what are the next steps? Refine and release outreach, case management help, and we're really dedicated to providing more peer support. So right now we have, like I said, the housing peer specialists working with our local housing provider, and then we have one or two health department provided peer specialists who are helping with our low needs drug education track in this program. We have a partnership with our local Tucson Police Department who provides peer specialist assistance for us. They are doing pre-charge deflection. It's called the UMatter program. And we have access to those peer support specialists if we need them. Also, if they're engaging individuals out in the community due to a law enforcement contact and they discover they're on either enhanced diversion or steps, they will have the peer specialists speak with them. And so that's another partnership I think is really helpful when you talk about deflection and making sure people don't come into the jail in the first place. But we are looking at ramping up even after that, peer engagement. So we have another peer specialist through another grant we're looking to get, and the health department is looking at other venues for funding for increased peer support specialists. In fact, I think the design we want to have is that, yes, we have pretrial service officers who are, reporting to court, they're monitoring compliance, and they're, making sure court date reminders get out. But I think the design we want is for those people that have specified needs, which is a large segment of our pretrial population and in the STEPS program. We would love to have a team of peer specialists who do most of the outreach and do most of the interaction, and who are doing best practices in the field work around engagement. So that's our vision for where things go, not just with STEPS, but with all our behavioral health and substance use population here in Pima County. The next thing too is, we're getting more judges involved in the program. So we want to look at potential expansion down the road. And that's pretty much all I have for my prepared presentation. So if there's any questions or comments, I'm more than happy to take them now.
Thanks very much, Domingo. And I'd invite folks, we're a small enough group, we can just unmute and ask questions if you'd like to do that, or put them in the chat. And I just wanted to ask kind of a broader question. This is such a well-formalized program at this point that you've articulated, and for sites that maybe are less far along in implementing some of these strategies within Intercept 2, and what would you advise as far as where to start? You mentioned partnerships a few times, so I'm sure that was a huge piece and still is, but even kind of before that point, how to start to build those, and early on kind of how you got started.
So I think it's the first thing I always advise, because that has come up from different jurisdictions, is looking at your data, knowing what cases are coming through your initial appearance court, seeing how well those cases are doing. I think having a data system in place to be able to, so what you said is correct, the stakeholder engagement and partnerships are very important, but there will be no buy-in if they don't see the need for it, or you don't have a way to give feedback and outcome measures to them, even if they're not the best. So our STEPS, diversion, and enhanced supervision populations don't perform very well. They're actually, there's a high failure rate, but because of the populations and because we report that, the engagement rate remains really strong, and they see a need for this population to be focused on. So I really do think that's the first step, is getting data squared away. And then I think the second thing too is, just having a philosophy around not having any overlap, between what conditions of release are and what you're doing with the behavioral health substance use population that's supportive in nature to get them to court, and or if you're going to divert them, keep them engaged with the program. Because I think that's where you can see a lot of, probably unintended negative consequences, is you set up a diversion program or a pretrial supervision program, and it's almost punitive if they don't do treatment. And that's something that we really try to avoid. So I think the data, and then having a strong philosophy that separates what you're trying to do from what their actual obligations are with the court.
Thank you.
I do have one question for you, Domingo. So with your high failure rate, and I think it's at 100% of individuals accept to be in a program at first appearance, but 50% show up. What happens to those folks? And do they have the opportunity to come back around for a second chance?
Yeah, so our prosecutor has been really good. Not just this one, we changed prosecutors. So the prior prosecutor was also very good at this too. They've been really good at, they usually dismiss some of those cases, and or they go down the regular prosecution route, and they're not going to appear for their first appearance either. And so if they fail to appear for that first appearance in standard case processing, they usually get moved back into, not maybe STEPS court, but they get moved back into SMART court, and then the supportive, work is still there in a sense. So, I think they try to dismiss as many cases as they can. And then if they come back in again, they're re-eligible for STEPS. I think if they're going to prosecute, it's usually because there's criminal history, there's past criminal history, and they're not going to let that case go, so to speak. But yeah, I think it's just case by case, but observationally, they're trying to get those cases dismissed.
Thanks for that.
Yeah.
And Domingo,
Hi.
Go ahead.
This is Molly from Allegheny County. I just wanted to ask a quick question. Thank you, Domingo. This was a great presentation. I'm curious, since you said the initial screening happens prior to the first appearance, how soon does that typically happen? Like how quickly is that screening happening? Usually
within 12 hours. So our initial appearance, if someone's arrested on a felony criminal charge, they have 24 hours to see an initial appearance judge. But our initial appearance court is in two 12-hour cycles. So it's usually within 12 hours of their arrest, usually. The max amount of time is 24 hours.
And I have one other question just to clarify. So it sounds like the participation in the program is not a bail condition. Am I understanding that correctly?
Right, correct.
Okay, thanks.
Yeah, I would strongly encourage that not be part of conditions of release. Strongly encourage it.
And actually, Molly, along that lines, and Domingo, I think, Domingo, you're in this nice position nationally to kind of understand some of those trends that are taking place and conversations that folks are having around pretrial and that kind of option of early treatment engagement. So I wonder if you can speak to that a little bit further about some of the conversations and what tends to be happening.
Yeah, so I think that's what I'm just talking about now is one of the things that I think is the biggest piece of the conversation is that, I think it's really easy to have a judge at the initial appearance say, you must adhere to treatment, and so that makes it really easy, right? Because then I think it's encouraging the defendant or participant to engage, and there's a punitive response if they don't. I think there's a lot of conversation around how do you do that without, how do you develop a successful program without having the stick, and so I think that's the one I hear the most about. Also, I think the resources at the front end, I'm lucky in Pima County, everybody wants more resources, I do too, but we have an office in our jail, that we use to screen and interview people before court, so we're housed inside of the booking area. So having that structure in place, a lot of pretrial agencies don't have that structure or have the resources to have staff 24/7 to accomplish the 12-hour screening. So that's a big challenge. That gets into a whole other, discussion about, getting resources from your funding sources and having the ability to do that. So then if you don't do that, how do you accomplish the screening and get people where they need to go, rather than hold them in custody and then do it after the fact? So I think that's a big challenge. Some other conversations involve, what do you do if someone doesn't comply? How does that response system look? Are you asking for a revocation? How do you manage that? How do you make sure your judges and your stakeholders remain committed to, understanding that just because someone's not doing treatment or not connecting to do their assessment, that doesn't mean they're violating the release conditions. So I think those are all the things that, when we have conversations, and I'll share this too, it's not just how to do it right. There's some pretrial directors who believe that this is not our job, that maybe pretrial agencies shouldn't be involved in this area of work. And I see those viewpoints. I see that how important, how important they think it is for just us to remain and getting people to court. But I also see the need to reduce failure, reduce risk, reduce harm, make sure people get the right, treatment. It's just having that delineation between that and pretrial conditions of release, I think, is the biggest area of conversation, and where I think most people struggle around getting the right, fine tuning their release programs.
Yeah, thanks for that, Domingo. It's a huge conversation across the country, and I'm glad you're in the middle of it in many respects.
Absolutely, yeah. And I will say this: I was when I first became in our administration, so not my position, I was just director, but what is now an assistant director. I did not believe wholeheartedly in doing this work. I was in the other camp, which is what we manage pretrial expectations. But then the more I saw, and saw that there were ways to do this without involving conditions and not pretrial officers. In other words, I don't think pretrial officers should manage someone's care or, make assessments about what they, what needs they have, but, sending that to someone else and then keeping that separate. I think I just needed that logical response to how we do it, rather than just, pretrial is you have a pretrial case manager who handles everything. That's not how that works the best in my viewpoint. So I've come to the show now at this point.
Glad that you're there.
Yeah.
Any other questions? Folks want to unmute? I think our chat box is clear now. Okay, well, thank you so much again, Domingo. We'll send out your slides with resources after today's call, so we appreciate your time again. And we will turn it over now to a colleague, Lisa May, to talk about kind of what happens if none of these things have been in place or been successful to this point.
Thanks, Ashley, and thanks everybody for tuning in today. You can see my screen. Is that good? All right. So just like Ashley said, what happens if folks don't get released at first appearance, or have the ability to be diverted, or have any initiatives with either the prosecutorial diversion or initiatives. And we all know that not everybody makes the mark, right? And they get returned back to jail after first appearance, or they aren't eligible. And we've seen our incarceration rates reduce over the course of the last 2 years post-COVID. However, what we've been seeing an upward trend is that even though the average daily population is being reduced, the percentage of individuals with mental illness and substance use is increasing within the jails. So let's talk about some best and promising practices. And certainly what we're about to share is not the catch-all, but we certainly want you to be aware of the foundational criteria of what individuals providing behavioral health services, substance use services within the jail need to be mindful of. It's not a clean cut, so we're kind of talking about in between intercepts, 2.5 maybe to 3.5 if you want to put a marker on that, but we're going to talk about a little bit of a half of intercept 2 and half of intercept 3. So as it relates to best practices, and we've seen this in litigation for many, many, many years now, that courts have held that incarcerated persons have a right to reasonable behavioral health care that's designed to, number one, meet their routine, and also have the opportunity to have 24-hour emergency mental health needs that would include diagnosis, preventive care, treatment, and rehabilitative services. So basically what that means is that once somebody comes into jail and they have been identified, right, to need either further mental health assessment or evaluation and potentially end up on a caseload, receiving an initial psychiatric, initial psychological, that's diagnosing them, that they receive routine care to treat their diagnosis. And if their care cannot be treated within the facility, or you have a crisis situation where an individual decompensates, that they have the opportunity and are afforded the right to be able to be transported to a facility that can meet their needs. So you all hear, and this really is for the individuals who are working within the jail setting or have the opportunity to have oversight of positional power to ensure that the level of health and behavioral health care within the facility is maintained. A lot of local jails have contracted providers, right, that provide behavioral health or mental health services, or it might be a local university, or even it might be a local, you might contract out through county services. But whoever's providing these behavioral health services, there's a constitutional level of health care that exists. And one is, and it's really broken into 3 parts: the right to access to care, the right to care that is ordered, and the right to professional medical judgment. So in a snapshot, the right to access to care, we just talked about that access to care, whether it's medical, dental, psychological, individuals who are incarcerated need to have a certain level of care. And if the denial of care might result in pain, suffering, deterioration, or degeneration, that constitutes indifference, right? And we have to make sure that we're never put in a position, in that position. The right to care that's ordered. So once an individual is identified, whether in the booking process, hopefully they're being identified during the booking process or during first appearance or through pretrial or whatever that booking may look like within the first 24 hours, we have to make sure that after that screening, that a licensed qualified mental health professional has the opportunity to further that assessment and have perhaps an evaluation. And then if necessary, then that is another upper level of provider, which would be a psychologist or a psychiatrist that considers them to, yes, there is mental illness that exists within this individual, and they are ordering them care. So individuals should have a right to care that is ordered. And also the staff, right? When we get on mental health caseloads and we're staying a significant or any amount of time within jail, that individuals should have a right to professional medical judgment, meaning that the people who are treating them are competent, qualified, certified, and that you have enough staff within the institution to be able to provide those services. So deliberate indifference exists and can either be an isolated incident or it could be evident from systemic deficiencies in prison or jail systems. This is what happens when individuals, when specific jails or jurisdictions get sued by the Department of Justice. The majority of jurisdictions have a systemic deficiency within their prison or jail system that is violating the 8th Amendment. So it's important for any correctional agency to make sure that they develop appropriate procedures, right? Every institution, facility that's providing mental health services should have, not only on the sheriff's security side, standards of operating procedures, but also have those contractors have a set of procedures and policies. And these procedures have to ensure the provision of constitutional care, which we just chatted about, and be able to withstand any challenges, right, about the adequacy of behavioral health care delivered to any persons who are incarcerated. So if you put it on paper, you should be able to deliver it and then back it up that you are able to deliver it. And the only way to do that is to have standardized operating procedures and being able to have quality assurance thereafter. So there's specific clinical protocols that should be in place in facilities that are treating individuals with behavioral health, mental health, substance use, right? Those standards of care, they will provide a groundwork, right, for the actual practice that needs to take place and the application of that care and those SOPs. So like I said, even though you might have not the sheriff's office providing those behavioral health or substance use services, but you have a contracted proprietor that's providing it, like maybe a NAF care or a correct care that's inside the institution or a university, they should have standard operating procedures, right? And it should be an array of services, from credentialing of your staff to the identification of individuals to what that treatment looks like. Evidence-based mental health treatment approaches are applied in the non-prison community, right? And if you're at a starting point and you don't know where to start with the community, because it provides a wealth of data and guidance to correctional mental health care professionals. But it's important to have SOPs and it's important to have standards of care. So staffing, I know workforce development, the great resignation, right? But when it comes to staffing for this target population, we have to say, and courts have deemed this, that it's logical that if a person who is incarcerated, that they have the right to basic mental health care, that it's reasonable to assume that it is being administered by people who are trained, people who are competent, people who are licensed, and people who are credentialed. And they then are enabled to provide a range of services. Staff size and availability. NCCHC, the American Psychological Association, a lot of different associations have specific staff ratios and availability. And if you direct a program or have any oversight or have the opportunity to kind of looking at staffing patterns, there's a lot of guidance from specific institutions and associations as to what your staff needs to look like compared to your mental health population. But how do you get to that? What Domingo said is the data, right? It's the data. Let the data tell your story. You cannot develop a staffing pattern, right, and assume what type of availability that would be if you don't know the individuals who are coming through your system. It's so important after the screening, like we're advocates, like 100% of the individuals, eligible individuals who are being booked into jail should be screened for mental health, right? Not everybody is going to end up on the mental health caseload, but that's the only fail-safe way to ensure that everybody who should be referred for further assessment or evaluation is being referred at that booking stage. If 100% of eligible individuals, and every jurisdiction should really define what eligible looks like, but 100% of individuals being booked into jail should have some type of mental health screening, whether it's the brief jail mental health screen, whether it's the CMHS, which you have the opportunity to have the CMHS for males and for females. Those are the two screenings that are free on the public domain that if your facility is not utilizing, we would encourage you to research how that could be implemented. So in way back, right, even to 1980, and I wanted to go back that far to show that staffing is an issue, and the lack of qualified staff within your institution that is matched up to the size of your mental health population has been determined to be deliberate indifference to serious mental health needs under some circumstances. But it's important to also recognize that things have changed, right? And what does those staffing patterns look like? So here is an example of what a staffing pattern may look like for your facility. You should always have, in the perfect case scenario, right? This is a perfect case scenario. A mental health director who's doing all of the administrative functions and a clinical director who, and these are best practices, who deals with the clinical aspect of the delivery of services, right? They are looking at the type of care that perhaps if there's a psychologist who's coming in per diem, or if there is telepsychiatry being conducted, or your counselors, whatever one-to-one that they're providing, or any group therapy. The clinical director handles the clinical things, and the mental health director will work on the administrative functioning with the SOPs and making sure that the clock is ticking, right? And then you have, so there's a number of positions allocated, your number of positions filled, and your number of positions vacant. This is an example of a staffing pattern, but you're not going to know how many positions you need unless what? Data. Unless you know over the course of time, you've been tracking, right? How many people have been screened in to your facility that potentially could land on the mental health caseload, and the ones who do get put on the caseload, and the ones who are on the caseload but have don't need any psychotropic medication, and the ones who do need psychotropic medication, those individuals who see a psychiatrist or a psychologist once a month, and even into tracking it by race, tracking it by gender, right? And having it over the course of time, even breaking it down by diagnoses and axes, will help you determine how many positions of what specialty you will need. So your qualified mental health professionals include your psychologist, your marriage and family therapist, your certified social workers, your licensed professional counselors. If you're really, really lucky, you'll have activity specialists, and you'll see activity specialists on the local level when you have the individuals who have a very, very long length of stay within the jail. Hopefully you might have a mental health nurse. Multifunctional correctional officers are not only trained in security, but they have some basic mental health training and our support and clerical staff. So of course, there's going to be some unique clinical challenges that every facility needs to be mindful of. And this is a promising practice, that there's some chronic conditions that incarcerated individuals experience, bottom line, at significantly higher rates than their counterparts in living on the outside or in the free world. So you're going to see higher people who attempt suicide. right? Within the jail setting, as opposed to the general population, not general population within the facility, but in the free world. You're going to have an increase in self-mutilators. You're going to have an increase in individuals with substance use and intellectually disabled persons. When we're looking at the whole total jail population and the percentage of individuals who attempt suicide or self-mutilate or are substance users or are intellectually disabled, that percentage of these individuals is going to be higher than the free world within the jail. So you might say, well, what type of data do we need to collect? It's always helpful within, and this is a best practice within jail settings, that you have a mental health dashboard. And this mental health dashboard, you should be able to basically report out on a monthly basis. That on that mental health dashboard, you should have some type of graph where you're capturing how you're identifying persons with mental illness. Like I said, the individuals on the mental health caseload, any juveniles, you should be tracking any juveniles under 21 that don't get out via diversion or at first appearance. How many folks are on psychotropic medication? You might have individuals who are on the mental health caseload, but not receiving any type of medication. So you want to be able to tease and separate that out. Disciplinary reports. Are your individuals on the mental health caseload receiving disciplinary reports from security? If so, you want to be able to track that. Self-injurious behavior, also SIB in lockdown. Are our individuals who are on the mental health caseload ending up in lockdown? Are they end up in ISO-SEG, whatever you're calling it? And if they are, is there a significant portion, not even a significant portion, but you should be tracking how many have self-injurious behavior while in lockdown? Assaults on staff, assaults on other individuals who are incarcerated, how many homicides, suicides, deaths, the total number of staff vacancies, how many are able to be diverted once they are on the mental health caseload, your reentry numbers. Everybody, once you are on a caseload, should have an individualized treatment plan. You should be tracking that to ensure that that comprehensive treatment plan is being conducted and it's also being signed, right? You can have a case manager or licensed professional counselor or a qualified mental health professional develop a caseload, develop a treatment plan, but that treatment plan should be talked with the person who's on your caseload, right? It should be signed by that individual for buy-in purposes and a lot of other implications. And those non-pharmacological interventions. So is there group treatment taking place, activity therapy, mental health counseling? And this is the type of data that you should be collecting on a monthly basis and be able to provide it at any given time to the security staff, whether it's the warden, the chief jailer, even when you're trying to solicit funding from your council council members, whatever you might need to gain stakeholder support, this is the type of data that you should be collecting on a monthly basis. This is what justifies your ask. This is telling your story. This will help you develop your staffing pattern. This will help you determine if you're contracting out to a independent contractor, the numbers to help guide what type of services and they'll be providing in addition to how much it should cost. So just to kind of on your dashboard, just an example, like assaults, January, February, March, this is the total 83, 71 would be assault on other individuals and other individuals who are incarcerated, and 20 would be on staff. So you're going to want to track your assaults and your dashboard. You know, there's so many you are afforded by so many tools via Microsoft that you can just, if you have access to those numbers, just create a dashboard and you're good to go. Self-injurious behavior incidents, you're going to want to track them, right? Just examples of what your dashboard can look like. And logs. one of the promising practices of making sure that your service delivery falls within constitutional levels, right, is that you should have logs. And those logs should be able to let anybody at any given point of time see your numbers and see individuals. So you have a referral log. Sometimes if they're not caught at that booking process, you know, somebody who's been in the jail 2, 3, 4 months can be referred by themselves, could be referred by another staff member. So you're going to want to track that, right? And record requests. A lot of times when we hear that we're seeking records from a community-based provider or for Social Security or for any reason, you should be tracking, right? Who's asking you for specific requests, what records, what agency they're from, when they asked you for it, if you had the proper release of information, if you sent it out, right, and how you sent it out and who you sent it to. All record requests on this population should be tracked. You should have logs of who ends up in ISO-SEG, how long they ended up, how long they were there, why they were put in ISO-SEG, and when they were released, any sexual allegation complaints that may come through this population or against this population, your observation cells. If you have one in your facility, who goes in the observation cells and tracking, right? How many times, right? Has persons from this population been placed in observation cells? I'm just going to go a little faster. We're running out of time. Discharge reentry. If anybody was placed on the suicide watch, activity therapy, if they had to be transported outside of the facility for a crisis stabilization, and alpha rosters. So really quickly, this is just a copy or an example of a records request. So you have the person who was incarcerated, their name, their ID number, Social Security, the location the records were requested from, the date they were requested, how you delivered them. You should always close the loop, right? To make sure that the records were received and any follow-up actions. If it's not documented, right? Social work 101, it didn't happen. Documentation, documentation, documentation is best practice. So your assessments and your evaluations should always be documented and signed off by upper level professionals. And you should have therapy notes. You should have notes on your one-on-one. You should have notes on your group therapy, and they should be maintained on every single individual who is incarcerated. Activity therapy services. I am an advocate of activity therapy. We will be able to give you these this presentation afterwards. Ashley will send it out, but activity therapists are individuals who are specialists, right? And they use activities in the form of active treatment to help people improve for their cognitive, emotional, and social functioning. These are possible activity therapy services that you might want to employ within your facility, wellness activities, pet therapy, music therapy. And this also is dependent upon your relationship with outside providers and security. All right. So finally, we are going to pick up with our next TA call on accountability courts and specialty courts. But very briefly, we'd like to say that there are, we want to just really share with you the estimated economic impacts and benefits. So when you have the ability to reduce an individual's length of stay within this population to a specialty court, you are going to see that healthcare costs to the state have been avoided, recidivism costs are avoided, foster care system costs are avoided. This is the opportunity for people to get referred out into an accountability court, shortening their length of stay, and then them being able to receive their treatment within the community for whatever purpose or whatever court was established. State income taxes paid if these individuals are employed. And we'll pick this up a little bit afterwards in our next TA call. And screening, and all specialty courts should have screening we do recommend that the brief jail mental health screen is used at jail or first appearance to constitute eligibility for a specialty court. Okay. So I know we ran out of time and I had to rush those past slides, but if you have any questions, feel free to put them in the chat. Well, actually, you could email us and we will make sure that we get you those answers to those questions.
Yeah, that's totally fine. Thanks, Lisa. These calls have tended to be a wealth of information that's kind of fire hosed at you in the 90 minutes that we have. So we appreciate your time, and we'll pack the slides full of resources and all of those things and send them out to everyone after today's call. And as Lisa said, we'll continue to kind of build on this in our next TA call in the series, which will be July 29th at 11:30 Eastern. And we'll send out a link to register for that one also. So thanks again to all of our presenters, and hope everyone has a great afternoon. See you soon.